Thanks very much. Hey, just before I get started, the topic today, of course, is alcohol and drug. And although typically we refer to alcohol drug testing, I want you to think about it in different terms, substance abuse and impairment, because the programs we develop, our objective isn't to set out to test people. It's to deal with on-the-job impairment and health issues. But just before I get underway, how many people in the room are involved in silviculture? Planters, planting operations? Road building? Harvesting? Okay. Another question, how many people in the room here are half Scottish, half Irish? Okay. So you'd like me, you like to drink but not pay for it. Right? Okay. I gotta make sure this thing works. Good. Bit of background. Mine isn't just academic pursuits. I, like Ken, getting out of high school, did a couple different things, including firefighting in both BC and Alberta. And I was a designated faller in Alberta. Then I moved to BC and I put the saw down. The environment in which BC harvesting, really my exposure, and planting is significantly different than than Alberta, that's for sure. The other aspects of background include industrial experience, including construction, truck driving, still remains one of my favorite jobs. Enjoyed driving semis. The more relevant stuff includes the law school, graduated in 1992 as mentioned, and business school to a certain extent, but also breath alcohol technician and instructor. So I was licensed in 1995, and we've been engaged in that as a company, Denning Health Group, since that time. Clients include current and former Weyerhaeuser, Tulco, Domtar. We just finished doing the Interforest program province-wide. We work with Western Forest Products, Island Timberlands, and Timber West. We cover Vancouver Island, entire thing from north to south. So how many people in the room are supervisors? Or supervisor owners and managers? Okay, as with the other presenters today, time is very limited. The topic is a very big one, tends to generate a lot of questions. I'm going to ask that you hold them, which is not normally how I roll, until we get to the accident investigation portion. So I'm going to, hopefully it won't be boring, get you to the point where you understand the topic that's being introduced, and then we will go over some accident investigation. My sense of it is, and I'm sure it is for the supervisors in the room, that when new policies are adopted, and I heard comment about paperwork from Russell a moment ago, it's on the shoulders of the supervisors where the responsibility falls. And that's a big part of what we're going to focus on today, is supervisor responsibility. The objectives objectives of my little presentation are set out on the screen. I want to lead you through to the point where we're going to talk about two types of investigations. We're going to finish up talking about Bill C-45 and WorkSafe BC changes. How many people in the room have had Bill C-45 orientation? Over here? So literally just a handful. How many people here have never heard of Bill C-45? All right, that's very common. And so the title on my last slide in overhead is that the sky is not falling in. I don't want you to quit your jobs, but I'm going to make you aware of the law as it now applies in British Columbia, and it's being enforced in British Columbia. So for those of you that have been exposed to Bill C-45, one of the comments is that, yeah, it's been on the book since 2004. It's hardly ever been implemented. But I'll describe to you the changes that WorkSafe has undergone since the botched investigations with the mill explosions that resulted in massive changes to that organization and direct cooperation with the RCMP in enforcing WorkSafe health and safety. And I'm going to plant this seed now. I could think of no better application. In fact, I would define it as a reasonable application as to enforce Bill C-45 against a supervisor who didn't exercise due diligence with regard to on-the-job impairment, regardless of the cause of the impairment, but I'm going to talk specifically about drugs and alcohol. So a supervisor who deals with a person who's impaired on the job and they have actual knowledge of that person being impaired, and they play it old school, that, you know, let it, as it was Ken that talked about passive sort of leadership, and, you know, let the person sober up on the job. If that person is injured or killed, or kills or injures somebody else, supervisor direct criminal liability. Okay, so I am putting that out there. I'm hoping to get your attention because I was going to lie to you and tell you it's raining out, but it isn't. It's a beautiful day still, and I know you want to get going, but I want to keep your attention for the balance of the presentation. So in your industry, how many people in the room here have never been exposed to someone who's hung over on the job? Anybody in the room? Never worked with someone who's hung over? Okay, thank you for being honest. How many people in the room have worked with someone who they knew or suspected was hungover or impaired from drug use? Okay, majority of the room. Thank you for being honest. Usually it takes quite a while for people to warm up and get cozy with me, but that's a good indication. Okay, so this overhead is outdated. The numbers since the testing programs we set up in the last year for industry, since it's been rolled out to contractors, these numbers up here have pretty much jumped in terms of positive rates. Not on a percentage basis, I should explain, but post-incident testing in industry up until it was adopted by the contractors ran at about 12% positive overall, and of those 12% positives, these are the drugs that were represented. Recently, units of my clients have had as high as 26% positive drug tests post-incident, okay? This is serious stuff, it's real. Skipping very quickly, there are only 2 legal objectives for adoption of a substance abuse and impairment policy in Canada. We're not in Alberta, remember. And that is a slight at the oil patch, by the way. And Alberta. I'm from Alberta, I can say that. Okay, so the legal objectives are improving health and safety, enforcing criminal law, enforcing morality. If those are improper purposes and will defeat a policy before it gets started. The only context, whether union or non-union, that you can properly advance your program, if you're considering it, is on the basis of health and safety. Clearly, this is becoming an industry standard. All major operations on Vancouver Island have adopted a program, and many other major companies are considering doing so in other parts of the province. Supervisors, as touched on earlier, it is, for those of you in the room, and owners and managers who also carry out supervision, it is on your shoulders that this and other policies rest. Very important that the basics and fundamentals of the program are understood. So, moving from supervisors, owners, and managers, every worker, including owners, managers, and supervisors, has a legal duty to the company to be fit for duty. It's expressed in a number of different areas, including WorkSafe, Workers' Compensation Act, I think it's Section 117 or 146. They cannot present or report for duty unfit for duty for any cause: fatigue, head injury, stroke, and illness, prescription drug use, or alcohol consumption, or illicit drug use. It makes no difference. It is the state of the person's ability when they present for work that is the measurement, not in fact necessarily why they are impaired, but the fact that they are impaired. Again, greater emphasis is going to be put on that when marijuana is legalized. And I stress that the legalization of marijuana will not change one iota the requirement of an individual to be free from impairment. If you have that in your mind, you can dispossess yourself of it. If you're working with employees who think, great, as soon as pot's legalized, I can smoke it on the way to work, not so. Alcohol is legal, can't drink it on the way to work. Oxycontin is legal if prescribed. If it impairs you, you can't use it. Right? Make sense? Okay, so moving on. We're going to move, in fact, 2 investigations, and we're going to talk about 2 primary investigations that are carried out by supervisors in the context of substance abuse and impairment. Both are legally required. In the events described that we're going to have up on the board, supervisors have a legal duty to act. Certainly in terms of accident investigation, there's statutory requirement. You have to report to WorkSafe. What's the time frame required to report currently to WorkSafe? Is it 24 hours? Anybody know? For doing accident investigation? It's 48? Okay, I just read about Nova Scotia I believe, adopted the toughest approach in the country, and they've moved it down to 24. And I thought I'd heard talk about that happening in BC too. In any event, that just reflects the legal requirement of investigation. Okay, accidents. Okay, how many people how many people represented in the room have a drug and alcohol testing program or substance abuse impairment in place? So we got one. Got any more? So not very many people currently have. Many companies, and sort of in the old way of thinking, would base the decision to drug test after an accident or incident or near miss just on the very fact that it took place. So if you have metal on metal is a common definition that companies apply. So anytime there's metal on metal contact, the people involved would get drug and alcohol tested. Well, I'm here to tell you today that that's an unreasonable position to take. I wrote Weyerhaeuser's program policy that was implemented starting in 2001. It was a 5-year project up to 2005. And their lawyers and I, often in conflict, not in cooperation, hammered out what we believed to be was a good test. Arbitrator Taylor agreed and endorsed the approach I'm about to show you. It's since been adopted by many companies, and it's the right and proper way to do things. So even if an incident and an employee were killed, or a serious hazard-created accident, or property damage, that in and of itself does not justify a drug test. It may now in your region, it may now, but my crystal ball gazing is that what I'm about to show you is the way that it's going to roll out across the province and the country. As driven by the policy and application of it, and applied by the people in the room responsible for supervision, the 3-step process is what I advocate, what it's incorporated in all of my clients' policies, and starting off with Weyerhaeuser 17 years ago or 15 years ago. First of all, the injury or the harm suffered has to be significant enough to justify a test. So it's as specifically cited in some cases, a spilt cup of coffee is not going to be sufficient. And I always like to add that unless that spilt cup of coffee is by an electrician working in a nuclear power plant, taking that coffee into some place he's not supposed to take it, then you'll see that would be a breach of a safety rule that might result in drug and alcohol testing. Okay, step 1, is it serious enough? Step 2, did the employee in question, did their acts or omissions contribute to or cause the accident? I have a client who very vigorously adopted drug and alcohol, huge fan. This individual pursued it from a moral perspective. He loved this tool. So it was when an employee's car was hit in the parking lot of the company, and the employee whose car it was actually up working in the office in a non-safety sensitive environment. She was a secretary. In fact, her car got hit, and he tested her. Does that make sense? So unrelated, no causal link between the employee and the harm. So even if that person who hit her car had been killed, it wouldn't mean that testing her would be seen as being reasonable, and there is no logical connection, not to my mind. Finally, if the actual cause of the accident was outside of the control of the employees, again, there'd be no reasonable basis for doing a test, not confused with reasonable cause. But there would be no causal link between the employee behavior and the cause of the accident. Everybody with me? I know I'm going really fast. So simple, it has to be serious enough. You have to show that the behavior of the employee caused or contributed to the accident, incident, or near miss. And third, you also have to be able to rule out mechanical or environmental factors outside of control of the employee. Okay. So what does a triggering incident mean? Well, your company can adopt a different definition. This is one that is in use with the majority of my clients. And a fatality is pretty straightforward. A personal injury or an injury, which would be defined as a recordable injury as per your company policy. You have to be careful how you word that. Damage to property. Some companies have zero, which is, in my opinion, wrong. Some have $10,000, which again, I think it sets a threshold too high. And once again, how many owners in the room? How many company owners? Okay, I want you to think, we don't have the time to discuss it, but think about the commonly occurring accident. And how many road builders here? Road builders, how many crushed culverts did you suffer last year? Too many. And what do you assign a value to each of those culverts? What, $2,000? But the cost to get them shipped in again to replace? $1,000? Okay. So that's $1,000. I have other clients where they're talking in the $2,000 range, which is why I jumped to that. And if you include the cost of the operation in terms of efficiency, it's also something to be considered. How many of those did you suffer in the last 2 years? A dozen. So if the costs were $12,000, that was $12,000. My other clients that have many more incidents where they're losing culverts, they've recognized by going through the program that they're talking about $50,000 a year in what is definitely a preventable incident. So as owners and managers, supervisors, I want you would look at what is a commonly occurring accident. Ask yourself if it's something that your culture really wants to continue to allow. Another good example is bent bumpers on pickup trucks. Anybody ever had that happen? Because culturally, people are, if there's an SOP regarding reversing, they're not following it. If there isn't an SOP regarding safe reversing, there should be one. And the training, touching on what Russell had to say, to make sure it's carried out. Okay, so whatever the level of property damage is set in your company, it should reflect your culture and your actual operating environment. The third one being environmental, that's driven, it's a very easy one, and driven by anything that you have to report to DFO or fisheries and oceans, what have you, that would constitute a reportable environmental incident. And finally, a near miss. I encourage clients to, by definition, say that a lockout violation constitutes a near miss. I often get pushback on that. But the people who are pushing back, and if you're one of them now, think it through. What is one of the most serious workplace accidents or injuries that it's sustained? It's often from failure to lock out. If you want to reinforce your safety environment, and again, we're not looking to drug and alcohol test people, we're trying to improve safety, bottom line. So a policy developed by your company often ends up being a medium through which many other safety objectives are achieved because it challenges the whole organization to review what they're doing. And it puts a spotlight on accepted but unacceptable behaviors. So damaged culverts from unsafe practice, reversing pickup trucks into something unsafe practice. And when the employees know that they may face an alcohol drug test, I guarantee you the response will be, holy cats, let's pay attention. I've seen it happen time and time and time again. About 10 years ago, there was a properly conducted study by Cornell University that looked at construction companies in the United States. And there, across the board, the companies that had adopted the drug and alcohol testing programs, as they call it, achieved over 50% reduction in workplace accidents. Weyerhaeuser's Drayton Valley operation back in the early 2000s was the third worst in the world for reportable incidents. Within a year, they went to about the third or fourth best in the world in terms of incidents. If you have a near miss, people could hide that. They could sweep it under the carpet. And this is an argument that you may have in your own mind. Well, if I bring this program into play, I'm going to end up sweeping accidents under the carpet. You can sweep, maybe 1-2 stitch things. You can sweep those under the carpet. You can sweep near misses under the carpet, possibly. What you can't sweep under the carpet is broken limbs, missing limbs, near-death injuries. And in empirical terms, those go down with the implementation of these programs. But I digress. We're supposed to be focusing on what supervisors have to do. Okay, so these are the 5 criteria. Any one of those, or one or more, would constitute a triggering incident. Questions that you have to ask then are, was there a job rule? Was there a JSA, SOP? If there was it in writing? If it wasn't, even if it wasn't in writing, was it communicated to the employee? With regard to training, and this touches on Russell's presentation, in fact, and from a legal standard, you'll have to show that that employee was culpable for their act or omission because they were trained properly or they were experienced operators. If you have a new employee who wasn't trained properly, or there was an accepted but unacceptable work practice from a safety standpoint, if that was in play, the test would be ruled unreasonable. Okay, so if you knew this employee was engaging in a dangerous work practice, they end up being injured, would it be right to say, okay, management supervisors knew that this was going on, and now we're going to drug and alcohol test you? I don't see it as being reasonable, and neither do arbitrators or the courts. Okay, so the standard of reasonableness is alive and well. Finally, ruling out other factors. So we got first step of this three-step test is, was it serious enough? 2, did the employee's acts or omissions cause or contribute to the accident? 3, now we're going to rule out environmental factors. And mechanical could be the cause, so the person gets into their vehicle, be it a loader or what have you, and if they don't have the responsibility of maintaining that machine and it's a mechanical failure that causes the accident, it wouldn't be reasonable to test that operator barring other circumstances. On the other hand, if they have, as part of your SOP is a daily inspection requiring them to check hydraulic lines, and they didn't do it, and had they done it, they would have seen the lockout tags from the mechanic, changes everything. Because then their omission directly contributed or caused the accident. Okay. This flow chart reflects what we've talked about so far, and it's an easy one that has been considered by arbitrators, and it works. We've actually modified it since this, but it's a flow chart. And these overheads, I see a number of people taking pictures. Gerard, if you contact Gerard, he'll send you the presentation. Yeah, okay? So you don't have to do this. Okay, so we're gonna pick a nice easy case, right? Because all the people in the room now are gonna be supervisors. So you have to apply this standard. Is it a triggering incident? Yes, no, all the factors. 2, did acts or omissions lead to the harm caused? 3, is there something out of the control of the operator or the employee that caused the accident? So I'm picking something really, really easy. Okay, everyone see what that says? Exxon Valdez, right? So if you skip back and go to the triggering incidents, damage to property, is it in excess of, what was it, $5 billion, $10 billion? We'll tick that one. Was it a reportable environmental incident? Quite. Close call, probably argue that on a couple different bases. So who would agree that Exxon Valdez is a triggering incident? Okay? Okay. Acts or omissions. Getting drunk while operating a ship, would that constitute an act or omission? And in fact, as it turns out, that poor guy got lambasted. Yes, he had a higher blood level. They had some legal or technical problems in proving that he was impaired at the time. His failing was allowing the person who he left in charge. That is really what caused the accident, and not properly monitoring. So it goes back to training, right? In any event, that captain got hung out to dry, no pun intended, but he certainly was impaired while on the ship. Okay, so who would tick that box? Drinking on the job? Anyone? Okay. Ruling out other factors. There's no other factors to rule out. So in this case, I would say testing that captain, as they did, would be a reasonable exercise of employer rights. Okay, all in the purpose of improving health and safety. Okay, now here's one that's probably closer to home. These are real life scenarios. Each of the ones I'm going to show you. There's only 3. This feller buncher operator just drove off a road. He tried to claim that there was a problem with the tracks. The supervisor, heads up move, went and took pictures of the tracks to debunk the guy's assertion that the machine pulled him off the road. It wasn't true. He just drove straight off the road. In fact, they think that he was distracted, cell phone, texting or something. I mean, the thing's not doing 60 miles an hour. You'd have to really be into your phone at that point. So he goes off the road, and what you can't see from this picture is just a few feet beyond where he stopped sliding was a steep incline. And had he gone over that, we would have been talking about a whole different story. What would you call that scenario then? What would it fall into? Anyone thinking near miss? So it was bad enough as it was, but he could have been killed. So the property damage, $40,000. So I would tick the box that this constitutes a triggering incident because property damage well in excess of that company's policy, which is $500. Secondly, there's an injury suffered. Did that, what caused this guy's injury? If you just read the, not wearing a seatbelt. So is not wearing a seatbelt related to the cause of the property damage, though? Kind of hard to say, right? He could have been bouncing and lost control, but in this case, we're assuming it wasn't. That it was a smooth road. He traveled it several times. He was an experienced operator. He just drove off the road because he was on his cell phone. That's what they think. Seatbelt. He broke a rule by not wearing a seatbelt, and that's what caused the head injury. But it's not what caused him to drive off the road. This is probably getting too subtle for the amount of time I have. But as supervisors, you want to document each of these scenarios somewhat separately. So you say he broke the seatbelt rule, and that caused the head injury. He broke a rule of inattention, and that's what caused him to drive off the road. So two separate bases to justify your decision. Okay, acts or omissions, clearly we just talked about them. Finally, environmental cause. He tried to argue that it was mechanical. By securing the evidence, the supervisor was able to prove that that was not true. This company, well, I'm going to turn it over to you. Would a test be reasonable in this circumstance? So yes? Anybody? So who says yes? Okay, so you fill all your forms out that I don't have for you today, but anybody say no? I know we don't have a ton of time. Is there someone? And we won't be attacked or assaulted. It's just, right? So the objective here is just to expose the ideas. Okay, so yeah, test was done. It wasn't legally challenged, but I would be happy to stand and defend the decision in this situation. Here's one. Let's go through it. Triggering incident. So I'm going to, because of limited time, I'm just going to give you the answers. Clearly, it's a triggering incident, $15,000 of damage. Near miss argument, you always have to consider the near miss argument. That deer could have come up and come through the windshield and killed the guy. It's not far-fetched. That's reasonably foreseeable. So that I would absolutely, it's a triggering incident on two bases, property damage and near miss. Step two, acts or omissions. Okay, who can see an act or omission that caused this accident? Someone over here, been quiet all afternoon. Acts or omissions, anyone? What's that? Yeah, so he didn't break a rule there. Wearing a seatbelt, no, it's necessarily material. Okay, so, sorry? That's what he said. Has to be what? That's what he said, though. Yeah, sure. Okay, why? Why? Because he said that the driver states that he was driving close to speed. We don't know that. Except that unless you had reason not to believe the report, right? So I would caution anyone from jumping to a conclusion. So and this all becomes contextual. Do you know the employee? Do you trust the employee? How long do they work for you? You know, so it's your fellow that you worked and known for 20 years, and I said, holy shit, you know, this deer just came out of nowhere. How many people here have hit a deer? Do you think you should have been drug tested? Okay, if they'd been speeding, if they had been engaged in some dangerous behavior, that would change it. But in this case, based on the facts, in spite of the $15,000 damage and the fact the guy could have got killed, what does the deer constitute? It's beyond his control. I've killed 3 deer in the last 2 years. You should have seen how far in the field I had to go to get that one. Yeah, exactly. Okay, so I wouldn't do a drug test here. I wouldn't. Okay, how about this one? Who thinks this is a safe work practice? This is real. How many people here would be inclined not to consider drug testing but termination? Yeah. So we're not upset at the drug test. Drug testing is a tool to help investigate circumstances. Okay? The objective is not to drug test or alcohol test. It's to determine whether it's reasonable, keeping in mind disciplinary considerations and gross violations of health and safety Discipline should be at the top of your list, including termination. Okay? So what these programs do, and I know this for 100% certainty, is introducing these programs to your company will refocus your company on safety. Things that are accepted but unacceptable practices will become a focus of attention in your company again. Okay, so I would consider termination as a starting point. If I didn't terminate, what do you think? Would drug testing be reasonable? I see a no. Okay, if we go back to triggering incident, what would you call this? It's a near miss, absolutely. How many pounds pressure if that thing, there's a problem with it, it's malfunctioning. Is there a piece of wood stuck and he pulls the wood out and now it closes? The guy's dead, right? Dead. So I think it's a trigger incident. Did his acts or omissions lead to it? Absolutely. He did not follow lockup violations. He was an experienced operator, putting himself in a very dangerous situation intentionally, not outside the control of his, outside of his control. So if he wasn't fired at drug testing, drug and alcohol, it's easy to get sucked in on these, and I know we're going rapidly. It's easy to get sucked in and jump to conclusions, and this is why I encourage people not to do that, to follow the process. There's 3 steps, and if you follow them, it'll keep you safe. So we're going to move on and on to reasonable cause investigations. What's the time? Do I have a time? It is? Okay. Reasonable cause investigations. You as supervisors, with or without a policy, makes no difference. If you go to work on Monday or whenever you're going back to work and you notice what you believe to be the odor of alcohol on an employee, you have a legal duty to remove that person from the work site until their ability to work safely is determined. If you see a person who's smoking a joint, off the job they go. If you don't do that, that's where the world of hurt starts to come in. Okay, this is nothing new. This is in existence right now. A drug and alcohol testing program, substance abuse and impairment, with the tool of drug and alcohol testing, gives you the tool as supervisor, owners, managers to deal with these problems in a way that protects you from human rights, labor law, and employment law. Okay, you end up with proof, not just your word against somebody else's. So, reasonable cause investigations based on a recognized legal criteria of specific objective observations concerning speech, odor, behavior, and appearance. Speech, odor, behavior, and appearance, SOBA. It is a recognized standard in countries that have the rule of law. And again, even without alcohol and drug testing as a tool, as supervisors, if you know that any of these have been compromised, that the more than the light going off or the bells ringing, you've got to do something about it. Okay? Don't jump to conclusions once again. We have had in the 20 years or 22 years we've been doing this, TIA, which is like a mini stroke, as a cause of impairment. We've had a number of undiagnosed diabetics who have been picked up as a result of the program. We've had stress, fatigue, head injury, ischemic heart disease that can cause, we've never had, to my knowledge, the chemical exposure, but I recognize that as being a possibility, right? So don't jump to conclusions. Again, I stress that. You can, don't jump to conclusions. The drug and alcohol test is to determine the cause of the impairment. If an employee, how many first aiders in the room? What is the outcome of leaving a diabetic untreated? Sorry? Coma, death, right? So if you had an employee who you smelt what you believe was alcohol, it could be acetone, in fact, or ketone, and they're demonstrating signs of impairment, but they say, hey, you know what, I'm a diabetic, that would be what? It's a medical emergency requiring immediate attention. That's a 911 moment. It's not a matter of carrying on the investigation. That can wait. Okay, right, so two broad drug categories, stimulants and depressants. Stimulants, easy way of remembering it, stimulate, they get big, they go faster, to more energy, and that's the effect it has on the pupils. The depressants, the reverse is true. Think of getting smaller, and that is the effect that it has on the pupils. The eyes are such a fantastic assessment tool. So, if you have an employee whose eyes appear like that, and they don't normally appear like that, what drug category would you be thinking? depressants. But you remember, you're only using or making these observations to provide a what? Reasonable cause. You're not trying to diagnose, but just drawing your attention to the difference between a normal eye and one that is of that size. And that card, by the way, is a tool used by drug recognition experts to help determine the possible drug that's at play. Okay, how about this? Who's seen that before? That's a trick question. Careful if you answer it. So, cocaine, amphetamines, methamphetamine. For those of us that have seen that in real life, that is not an exaggeration at all. And in fact, I've seen people that have, I don't know if this has a laser pointer. Gerard asked me, and I think I said no, where the iris is even larger. Less of the iris is showing than that. Okay, it's almost all pupil. Is that normal? Speech, odor, behavior, appearance. That falls into appearance. So if the only symptom you saw in an individual were their eyes that appear like that, should they be going to work? Right? There's something going on, and you as a supervisor have a legal duty to investigate it. You can't let that person go to work. No one's ever seen this before, right? Okay, so marijuana, off the job, what an employee does, that's their business. Crack, crystal meth, cocaine, heroin, amphetamines, alcohol. What they do on their own time is their business until what they do affects the safety on the work site and productivity. Then it becomes not only the employer's duty, but it becomes from a health standpoint, it's a duty from a safety standpoint. So you have a duty to do something about it. Hey, how about this one? First aiders again. The answer is given away in the top, and we've had this circumstance arise in a TIA situation. So you would suspect head injury. You may want to pursue drug and alcohol testing investigation, but that would be a second thought after the fact. Wouldn't be your first line of inquiry. We've had people who have glass eyes, and they've explained why they appear like that. True story. But yeah, anybody appearing like that would constitute an emergency, unless they have a glass eye. What's another explanation? What could have happened there? Or back here even. They could have been at the ophthalmologist or optometrist. Should they be at work? Not until those symptoms go away, right? So, okay. Briefly, we're going to talk about alcohol. Here's the bright side. You know, it's a nice hot day. You're probably going to go home, maybe have a beer or drink. So this is meant to represent. And then there's the flip side. Okay. So this is also a reality, right? Not every night of drinking turns out so well. You're not too worried about this one. Oops, that one, as long as that's where it stays in reasonable limits, but you should be very worried about these ones. Okay. The law states 0.04 and above constitutes impairment for workplaces in Canada. Don't have time to go into the science and math behind it, but that's what the law says. Most companies adopt a policy which provides for penalties or discipline below that, including a minimum suspension of usually 24 to 72 hours. So, but what is so important to understand about alcohol is the rate at which it leaves your body, and it's very well understood. So if you did a scatter diagram of everyone in this room, most of us would fall into a center where the alcohol is digested in our body at a very specific rate. You pee it out, you breathe it out, and you sweat it out. Poop it, a little bit in your poop. It's very specific. Sweat, breathe, pee. 3 ways that alcohol leaves your body, well understood. A bunch of other factors, gender, race, that are factors, but by and large, people will digest the alcohol at a consistent rate. These numbers are very real. People that get highly impaired at night, or when they go to bed, whatever time, chances are those employees are showing up well beyond the legal workplace limit in Canada, 0.4. They are quite likely driving above the criminal standard of 0.08 and above the provincial standard of 0.05. If you have an employee who shows up at 8 in the morning or you notice them at 10 in the morning, whatever time, and you say, gee, I smell what I believe to be is alcohol coming off you, of course in private. And they said, yeah, I had 3 beer with dinner last night. Each beer equates to about 0.015. So at the time that they finished drinking that alcohol, depending on over what time frame it was consumed, that alcohol would be all gone from a person's body within 3 hours. If your employees are trying to tell you that they still smell of alcohol, hours after they say they've consumed it, then there's really no other conclusion that can be drawn. Either they have no liver, or they're lying. And they either had way more to drink the night before, or they're drinking where? On the job, okay? So any level of alcohol while on the job requires supervisors to investigate further. End of story. I've heard the idea, I'm sure, that you can have a shower, to sober up, then you're just a clean drunk. Or eat, you're a full drunk, right? Or coffee, you're a jittery drunk. Is it none of those three things will sober you up any faster? Coffee, because of the stimulant, has been shown to elevate awareness, but not motor skill in any significant way. So you drink coffee and become more aware of the fact that you're drunk, but doesn't really help you. Okay. So we're getting on to the last section here. Bill C-45 is new to most people in the room. Only a few hands went up when I asked whether or not you had taken a Bill C-45 course. This is intended to get your attention, not to scare the shit out of you entirely. In the cases that have gone through so far have been limited, but specifically to British Columbia. Well, actually, I'll say that for a moment. The changes to the criminal code came as a result of the Westray mining accident in Nova Scotia, in which 26 people were killed. At the time, the federal government, prosecuted the company, tried to, and the individuals involved. Some poor sap panicked and admitted his liability, and he was the only person convicted in the death of 26 people. Everyone else involved, managers, directors, kept their mouth shut, and they were all acquitted, or charges were stayed, because the Crown lacked the tools at the time to associate the culpable behavior with the death of the men. Laws have changed. Bill C-45 is more results-driven, if you like. And in the event of a serious injury or workplace fatality, the Crown has what I would suggest is a much lower threshold, and that they can, they've rewritten the book when it comes to criminal law. And so if you have a serious injury or fatality, and you're the supervisor, and you haven't exercised due diligence, or you knew that person was impaired, worst case scenario, and you let them go to work, here's what can happen. So supervisors, up to life in prison, 10 years for bodily injury, up to $100,000 fine for supervisors. Fines cannot be paid for by the company. Any fines levied under Bill C-45 are personal, and the company cannot indemnify you. And the Crown quite rightly took that step, because otherwise it would be a matter of whatever the path of least resistance. If engaging in this dangerous behavior saves us $200,000, and you're only going to get fined $100,000, there may be an argument to go ahead and engage in that dangerous behavior. So that's for the individuals. For companies, unlimited fine. Okay. Christmas Eve 2009, Toronto. 6 workers working up at 110 feet, 2 safety lines. End of the day, guess they want to get home. Turns out they've been smoking pot recently, 4 out of 6 of them, or 5 out of 6 of them. They only have 2 safety lines, 4 people get killed when the scaffolding collapses. There's other problems with the scaffolding, but had they been wearing safety lines, they would have been alive and gone home to enjoy Christmas that day. So they are prosecuted under Bill C-45. Companies found liable, supervisors found liable, the director, although not even there, found liable. How many people in the room are directors? Directors of your company, right? If you own your company, you're a director. Director's not there, they have no knowledge of it. They can go to jail, but in this case they're fined $90,000. The company was fined $200,000, which sounds like a lot of money. The Crown said, what, $200,000 for 4 dead people? That doesn't sound like a lot of money to me either. They appealed to the Court of Appeal, who agreed with the Crown and increased the fine to $750,000, even though, and the defense argued before the court, that would put that company into bankruptcy. The court went out of its way to say that that was not a consideration for the court to look at, that the purpose of the law is to deter other people from engaging in that act. It's deterrence, not punishment, in a sense. So they increased it $750,000, wiping the company out. Supervisor, who had a stellar safety record, and the court recognized this. See where am I at? Was given 42 months in prison. Dad, 3 kids, and the court specifically recognized that what he did in allowing those 4 people to go on the scaffold without safety line constituted a momentary lapse in judgment. But again, the court stressed that this speaks to the exact reason that Bill C-45 is adopted, which is to stop supervisors from taking shortcuts. So when you go to work, think about that. Are you allowing shortcuts? Are you taking shortcuts? Changes to workplace safety in British Columbia as a result of the mill explosions, which were botched by workers' comp, specifically criticized by a number of people, including Premier Christy Clark at the time, publicly criticizing. They changed their whole organization to have a bifurcated approach. They have enforcement and they have investigation. If enforcement, which typically shows up first, finds anything that they are concerned about that may lead to criminal behavior or what they may constitute, which really means any serious injury or a fatality. They, by way of a memorandum of understanding with the RCMP across the province, will notify the RCMP if they haven't already been. The RCMP will be brought into the investigation, and if the RCMP come in, they get jurisdiction and they kick workers' comp out. So that is the shortcutting that process. I happened to have a seatmate not too long ago who was the RCMP in charge of going all across the province, training all of the RCMP detachments specifically for workplace accident investigation to determine whether or not charges would be laid under Bill C-45. So this isn't new. I stress that, right? It is not new. What, if you didn't know about this 20 minutes ago and you know now, the only thing I'm wanting to do is to draw it to your attention, make sure you're aware of this, and then loop it back to your responsibility as a supervisor and not allowing unsafe work conditions to occur, all right? And if you have actual knowledge and haven't, well, if you have actual knowledge and haven't done anything, by definition, you've failed in due diligence. Bill C-45 is very real. So the Queen of the North fellow, he got a similar sentence to this man. He also got a 10-year prohibition from operating a motor vessel, ending his career. And he was fined and imprisoned. Okay? So that's a BC application. Yeah, the sky's not falling in. This is just drawing your attention to the realities, modern day operating realities. I do want to mention this, that in the event, God forbid, that you have a serious injury or workplace fatality, you have a statutory obligation to notify workers' compensation, right? WorkSafe. My direct and very specific advice to you is to then call your lawyer, or call your lawyer first. When you make a report to workers' comp, you just tell them the incident took place, don't just hang up. Meet your statutory requirements so that you're not found to be in violation. If that has its own set of risks, then call your lawyer. Right? You need to get legal advice from folks that know workplace accident safety, not your corporate lawyer, not your tax lawyer, or your family lawyer. You need to find somebody who knows what they're talking about. So ends my presentation. I promised Gerard I'll leave time for questions. Maybe there aren't any and everyone wants to just go home. Thank you. Oh, go ahead. Well, absolutely. That's why the question was, well, what about, you're talking about drug and alcohol, what about fatigue? I totally agree. And that's why you don't jump to conclusions. Drug and alcohol testing is just a tool to determine the cause of the behavior. So if the person claims that they're tired, but their eyes look like this, well, you could do roadside sobriety tests for impairment due to anything. So regardless of what it is, head injury, stroke, heart attack, diabetes, the walk the straight line, all that kind of stuff, it's a very valid form of getting a baseline, no doubt of it. Okay? So should people be working if they're impaired? No. It does matter what the impairment's caused by, because if you have a new baby at home and you didn't get any sleep, you can go home and get some sleep. But if you're addicted to crack cocaine or doing oxycodone, you're not going to go home and just be able to, quote, sleep it off, right? It's not going to go away. Any other? We've got a little bit of time left. Oh, go ahead.
The one that I've heard from some employers is changes in prescription medication may cause issues.
Changes in prescription medication, absolutely. So just because the substance is prescribed and legally consumed, does it make it safe for the workplace? We don't know. If they're exhibiting signs of impairment, that is the test, right? So associated with oxycodone, from a health standpoint and safety, right? Leading cause of addiction to heroin, another opiate class, leading cause of death in the province right now, using drugs laced with fentanyl. People that are engaging in that behavior right now are rolling the dice because they don't know whether or not their opiate or crack or crystal or what have you has been laced with fentanyl. So by very definition, in my opinion, anybody in this day and age deciding to engage in that behavior is not thinking clearly. Make sense? Right? But we're not enforcing morality here. That's health. When their behavior off the job affects on the job safety and productivity, then it becomes your business and your duty. Okay. Anybody else? Yeah. So the question was, does WorkSafe contact RCMP? And I was sitting beside the guy on that flight, specifically told me that they have a memorandum of understanding between the agencies. And I was on the flight with them it was last fall, just after they'd inked it. Whenever it was I was on the flight with them, they just inked the deal. So province-wide injury, serious injury, fatality, RCMP are notified. Go ahead. So the person was determined to have used the drugs while on the job. Yes. The scenario you're painting for me would suggest that the employer did not have an opportunity to even exercise due diligence. I would suggest no liability under Bill C-45. So, but it's where you have actual knowledge or did not exercise due diligence, you're basically toast.
How would providing naloxone in having it in first aid situations show complacency in potential drug use for employees? Because we want to have it just in case, because if we work on a remote job site, but we also don't want it to show as we're increasing liability as like some sort of complacency towards drug use.
The question related to Noxalone, which is like Narcan, it counteracts the effects of opiates in the brain and can stop an overdose from happening. Easily administered, but you need to be trained to do it. So if you rescue someone and do so negligently, resulting in their death or injury, you'd be liable for that. Simply having the counteracting agent with you, I don't think that you're going to attract liability. But if I were cross-examining you, I would ask you, why do you have that? So you don't have to answer this. Do you have actual knowledge of your employee group using opiates? So my message to anybody in the room that has the same thoughts, if you know your employee group are using opiates, you need to do something about it, not waiting for drug and alcohol testing. You need to do something about it right away. So there's a whole sort of a trap. If you know of a hazard and try to address it, yes, there's an argument that you could attract liability for it. The question becomes this: did you treat the hazard? Did you give them the opiates? Did you give them the fentanyl? I'm hoping the answer is no. Right? So you didn't create the hazard. They did it. But if you have knowledge of it or you're not exercising due diligence, all bets are off. They really are. So short answer, no. I don't see any liability in that, well, unless you have knowledge. Okay, thank you very much.